So the second presentation that I will have today is totally different from the first one. It's not so dense, and it's more interesting because I have a personal experience with this subject. The second presentation is about the role of the state agent before the European Court of Human Rights and within the Council of Europe legal system. So this role that I will discuss now is in certain sense, at least for me, one of the most important roles in the convention system that some people never heard of. And I'm saying this from my personal experience since I have been almost 4 years a state agent, Serbian state agent before the European Court of Human Rights. And I want to say at the beginning that the state agent before the European Court of Human Rights is not a judge, nor a legislator, nor a minister. The agent appears in a formal architecture of the convention system as a representative. And yet, as I hope to demonstrate over the course of this lecture, the state agent is one of the most significant actors through whom the convention mechanism either functions very well or sometimes fails. And to explain this, I will begin with the central idea of this lecture. State agent occupies a dual institutional position that has no precise parallel in domestic legal system. On one side, the agent is a defender of the state before the international court. The agent receives the court's application, prepares the government responses, argues the case, and protects the state interest throughout the entire proceedings in Strasbourg. And this is the litigation dimension, which is very visible and very familiar. But on the other side, and this is what makes the role generally unique, the same agent, after a judgment of the Strasbourg court is a violation, that same agent becomes the person institutionally responsible for ensuring that the state complies with the judgment. It becomes the person institutionally responsible for ensuring that the individual who brought the case actually receives what the court determined they are owed. State agent becomes the person institutionally responsible for coordinating the domestic measures necessary to prevent the same violation from reoccurring and happening again. And the state agent becomes the person institutionally responsible for standing before the Committee of Ministers in Strasbourg and demonstrating with credibility that the state has made its obligation seriously. And this is not a secondary function, it is the second, equally demanding dimension of the same role. This means that the state agent who argues against the applicant at the litigation state is, after the judgment, the person charged with ensuring that the applicant's rights are actually justified at the national level. And that transformation from adversary to advocate for compliance is the most distinctive and the most unappreciated feature of this office. So in my presentation, I will address 4 questions. The first is this role regulated and on what legal basis? The second, what are the specific boundaries of the agent's performance? Third, should the role be regulated further? And what would adequate national regulation look like? And the fourth, what does it all mean in the practice? And I will present the Serbian experience, including my own experience, as I said, being a 4-year state agent of the Republic of Serbia before the European Court of Human Rights. So, legal foundation. Any analysis of the state agent role must begin with the question of legal basis, with what the convention system has formally prescribed, and equally important, with what it has deliberately chosen not to prescribe. The principal formal provision is Rule 35 of the Rules of the Court, which establish that contracting parties shall be represented by agents who may have the assistance of advocates or advisors. This provision is the procedural base for everything that follows. And as you can see, this provision of Rule 35 of the Rules of the Court is minimal. It established the existence and the necessity of the agent, but it does not say anything about how the office is constituted, what qualification is required, what autonomy it holds, and how its mandates related to the broader obligations the state has assumed over the convention. And I think that this minimalism is not accidental, or I think it's maybe purposed, that it reflects a considerable structural choices within the system that must operate across legal orders of very different constitutional characters. The convention binds 46 states. Some of them are federal, some of them are unitary. Some have presidential, some parliamentary mechanisms, systems. Some are focused on common law, civil law, long-established democracies, and some are very young constitutional systems. To prescribe in detail how each state must organize its representation before the Strasbourg Court would be both inappropriate and counterproductive. What the system requires is not institutional uniformity, but functional reliability. A single authorized representative through whom the state engages with the court and through whom the court can address the state. And Rule 35 of the rules of the court achieves exactly that. It established procedural unity and the international level while leaving institutional organization entirely to domestic determination. The convention provisions surrounding the agent are the following. To understand the full framework which agent operates, Rule 35 must be read together with substantive provisions of the provision of the convention that engage the agent's role against the full development of the case. First is Article 38 of the convention that provides that the court shall examine the case together with the representatives of the party. So it says representatives, not state agent. And this provision locates the agent within the bilateral structure of the convention proceedings as the party representative who stands along the side with applicant through the court's examination of the case. The agent is, in this sense, the state that is procedurally present before the European Court. Article 39 of the European Convention governs the friendly settlement procedure and establishing mechanism by which the court may facilitate an agreement between the parties that is concluded on the basis of respect for human rights. The agent negotiates these agreements on behalf of the state and assumes the legal authority to sign them. Article 46 of the Convention is probably the most consequential provision for our purpose. It establishes the binding force of final judgment and the obligation of high contracting parties to obey them with supervision entrusted to the Committee of Ministers. It is this provision that generates the execution dimension of the agent's role, the obligation to implement, coordinate, and demonstrate compliance at the national level. It is this provision that creates the structural context for the dual nature I described at the opening. The same agent that is bound by Article 46 of the Convention is the state that agent represents, and the agent is in most member state systems the primary institutional actor through whom the obligation is to apprise court judgment domestically. Rule 60 of the Rules of the Court adds a further procedural instrument, a unilateral declaration by which the state may acknowledge a violation and commit to providing redress without requiring the applicant's acceptance. This mechanism is often used in appropriate cases as an effective means of resolving proceedings. It is signed by the agent and constitutes one of the clearest expressions of the agent's dual function. The agent who has defended the state's position exercises an authority that implies recognition of responsibility, a commitment to remedy the case at the domestic level. Taken together, these provisions establish a coherent but intentionally incomplete framework. They confirm that the agent is the procedural face of the state before the Strasbourg, and they place the agent in every significant moment in the case, from the initial observation to the friendly settlement, from the hearing to unilateral declaration. But they leave open by design everything that determines whether the agent can actually perform those functions with the authority and capacity that the convention system requires. And the question of whether the agent office sits within the government, whether in the Ministry of Justice, the Ministry of Foreign Affairs, the State Attorney Office, or autonomous structure is left entirely to the member states. The question of how the agent acquires the information needed to represent the state effectively is a matter of domestic regulation. The question of what authority the agent holds over other national institutions when coordinating and executing the judgment is resolved at national level. and the question of whether the agent has an institutional resources to perform the litigation and execution functions simultaneously, a question that turns out to be among the most consequential in practice, depends entirely on decision made at the national level. And this is precisely why the role cannot be understood by reading the Convention alone. The Convention established the requirement of representation. It does not build the institution that delivers it. That construction is the responsibility of member states, and the quality of that construction varies considerably across the 46 legal orders we are going to discuss. A brief comparative survey illustrates the range of that variation. For example, in Germany and Bulgaria, the agent's office is organized within the Ministry of Justice. In Estonia, Latvia, and Netherlands, it sits with the Ministry of Foreign Affairs, reflecting a conception of European Court of Human Rights representation and as an aspect of international relations rather than domestic legal administration. In Croatia and Montenegro, the agent heads an autonomous office with direct governmental attachment, and it's not subordinated to any ministry. In Azerbaijan, the office is positioned within the presidential administration. In Serbia, since 2015, the agent is simultaneously a deputy state attorney working within the state attorney's office. In Slovenia, no single agent is designed. Representation is distributed across the state's attorney function as a whole. In Bulgaria, 9 agents share the caseload. So the diversity is not a deficiency of the system. The Council of Europe's own guidance materials treat it as an accepted and expected condition, one that follows necessary from the deliberate choices not to describe institutional form at the European level. What those materials insist upon consistently is, with increasing sufficiently over the past 15 years, its adequacy of function. The system standardizes what the agent must be capable of doing. Now we arrive to the analytic core of this lecture, what the state agent actually does and how these different functions relate to each other. I want to describe 4 roles. They are not separate jobs. They are 4 dimensions of the same office. And they are all organized around the dual nature I described at the opening. The agent as a defender of the state, an agent as a person responsible for bringing justice to the individual after a violation is found. Role 1, litigation, defending the state. The first and most visible role is litigation. When the application is filed against the state, the agent prepares the government written observation, the formal response to the applicant's complaints, response to the applicant's arguments, attends oral hearings before the European Court if they organize some, and manage the government procedural strategy throughout the case. And I want to describe why this role really involves, because it is more complex than it looks like. The state agent is not simply a postman who forwards documents from ministry or courts, Supreme Courts, Constitutional Court to Strasbourg Court. The agent is making strategic choices at every stage. Which facts to highlight and which to contextualize in the written observations. Whether to raise admissibility objections or to go straight to the merits of the case. How to frame the state's arguments about proportionality or the margin of appreciation. Whether the state domestic remedies are strong enough to support a non-exhaustion objection. These are judgment calls and they have consequences that go far beyond the individual case. Consider, for example, non-exhaustion argument. When the state agent argues that an applicant should have used a domestic remedy first before going to Strasbourg, the agent is making a claim about the entire domestic legal system and not just about one procedure. The agent is saying very clearly, our courts are effective, our remedies are accessible, our system works. And if the Strasbourg Court accepts this argument, it validates the domestic system. However, if the courts reject it, the judgment often includes a finding that domestic remedies are inadequate, and that finding echoes far beyond that single individual case. And this means that the agent in the litigation role is doing something that goes far beyond ordinary representation. The agent is presenting state's legal order at the international court. He or she is a person through whom the court forms its understanding on how domestic law actually functions. The litigation role also includes two procedural tools that I mentioned. The first one in friendly settlement under Article 39 of the Convention, and a negotiation resolution where the state acknowledges, at least implicitly, that something went wrong and offers the applicant compensation and other redress. The agent negotiates and signs these friendly settlements. The second is a unilateral declaration that I mentioned under Rule 60, where the state acknowledges a violation and commits to remedy it without requiring the applicant's agreement. And in both cases, the state agent is acknowledging responsibility and arranging redress. Second role is from litigation to execution. The agent as coordinator of compliance. And this is, in my view, the most important and most underappreciated dimension of the state agent role. When the court finds a violation, the agent job in most countries doesn't end there. It transforms completely. The agent who has been arguing for months, even years, that the state acted lawfully, must now, often immediately, sometimes simultaneously, become the person responsible for ensuring that the violation is remedied. That the applicant receives what the Strasbourg court said that the states own, that the system which produced the violation is repaired so it does not happen again. Before I describe how it works in practice, I will explain it, how it happens institutionally. Once a court judgment becomes final, supervision of compliance passes to the Committee of Ministers. This is the main political body of the Council of Europe, composed of foreign ministers or permanent ambassadors that sit in Strasbourg of all 46 member states. The Committee of Ministers does not adjudicate. The Committee of Ministers supervise, and their job is to watch over what each state does in response to European court judgments, and to keep watching until it's satisfied that the state has done enough. Within 6 months of a judgment becoming final, the state must submit an action plan, a document that describes what it has done and what is planned to do to remedy the violation at domestic level. As measures are taken, the action plan is very often updated. When execution is complete, the state submits an action report. Then the Committee of Ministers closes the case with a final resolution, or if the Committee of Ministers is not satisfied, it keeps open the case and may adopt an interim resolution, putting political pressure on the state to do more. Some cases remain open for years, as we saw in a previous presentation, and some even for decades. The agent role is in most member states is the center of this entire process. The agent, and this is where the dual nature becomes concrete. The agent who argues the case against the applicant is now the person responsible for making justice and become reality at the national level. This is not in formal legal sense. The agent still remains a government official, but in a real practical institutional sense, it becomes a lawyer of the applicant. With the execution process, the agent job is to push the state authority to comply, to press ministries that are slow to act more fast, to identify the individual and general measures required, to prepare and draft action plans and action report that generally commit the state to change, to stand before the Committee of Ministers in the debates and defend the adequacy of those measures. If the agent does not do this work, the judgment very often remains on paper, and the applicants get sometimes nothing, and the structural problems resist, and we saw in pilot judgment procedure, and the legitimacy of the entire convention system may be damaged. The third role of the state agent is convening the state and coordination. It follows directly from the second one. Execution does not happen in one office. It requires action from multiple domestic institutions. Very often, ministries, courts, prosecutors, police, administrative bodies, legislators, and sometimes even budget office or the Ministry of Finance. None of these institutions has an autonomic reason to cooperate with the agent. None of them is subordinated to the agent in the normal hierarchy of government systems at the national level. And yet, they all need to act in a coherent, timely way for the judgment to be executed. And this is the coordination role. And it's where the institutional design of the state agent matters the most. The Council of Europe 2017 Good Practice Guide describes this role in concrete terms. Agents organize interministerial meetings, write to ministries explaining what is required and by when, commit to the measures ministry proposed, escalate to cabinet level when a political decision is needed, and require timely replies so that action plan can be submitted to Strasbourg on schedule. The 2011 roundtable that was organized in Strasbourg on the same recommendation that was adopted by the Committee of Ministers added that this convening function is especially important in cases that touch several governmental departments simultaneously. I will explain this through example. Think about the case involving the excessive length of criminal proceedings. The Strasbourg courts find a violation of Article 6 of the Convention. To execute that judgment properly, you might need a new legislation on court procedure, maybe more judges, the digitalization of court records, a new compensatory remedy for people already affected, and training for judges and court lawyers. Each of these measures involve a different ministry of institutions. None will happen automatically, and some has to map out all the required measures, assign them to right bodies, set a clear timeline, and keep the whole process moving. In most states, that someone is a state agent. And I want to say something that comes from my personal experience of the official documents tend to understate. Coordination is really smooth. Ministries do not always respond. Deadlines are frequently missed. In politically sensitive cases, resistance is not accidental. Sometimes it is deliberate. The agent operates in a sphere and a space where legal obligation consolidates with administrative reality, where progress depends on formal authority, on persistent negotiation, and at times genuine institutional pressures. The skills required here are different from litigation skills. You need the ability to negotiate with resistance institutions, and you need to know when to push and when to wait. The fourth role is guardian of the convention at the national level. And it is the least visible, but it has grown significantly in importance over the past 15 years. The agent is also, in many systems, the principal domestic expert on the convention matters, the person who monitors how domestic law and practice compared to the standards of the court is developing in Strasbourg, who alerts the, other institutions, domestic, when a domestic provision may be incompatible with the convention, and who disseminates the knowledge of the court's case law to domestic courts, prosecutors, and legislators. And this is the convention guardianing role. It goes to the heart of what post-Interlaken reform process has been trying to achieve, a shift from reactive compliance, fixing violations that already happened, to more proactive compliance, preventing violations before they reach Strasbourg. If the agent is doing this fourth role very well, the agent is contributing to reducing in the number of applications filed in the first place. And how this role is performing by ensuring domestic courts know the relevant case law of the European Court, by flagging incompatible legislation before they produce violation, by training officials in convention standards, the agents thereby become the person who helps make Strasbourg cases less necessary. All four roles are linked, and they all express the same underlying function. The agent is the institutional point at which convention obligations become operational within the domestic legal system, the person through whom international human rights meets the internal functioning of domestic system. So now that we understood what the agent does, we can ask the next question with more precision. Is the current level of regulation sufficient? And I want to answer this in two levels, European and national, because the answer is generally different at each. At the European level, there has been no move toward forward coordination of the agent's role, and I think unlikely it's going to be one. There is no conventional protocol defining the agent's role, no binding instrument specifying required powers, qualifications, or execution structure. What the European level has done instead, and this is more significant than it might appear, is progressively accumulated functional expectations through political declarations and good practice instruments. These are not binding in the strict legal sense, but they are not without the force. When the Committee of Ministers adopts recommendations, when a high-level conference produces a declaration, when an expert group publishes a good practice guide, these documents create a normative environment that shapes what member states are expected to do. And the direction of this normative environment over the past 15 years have been consistent in conclusion and recommendation in that the agent's office must be able to do more. More coordination, more execution, more dialogue, more authority, more resources. We will examine the specific declaration in part 4 of my presentation. For now, the key point is this. At the European level, more formally binding regulation is probably neither desirable or achievable, because national diversity is a feature and not a defect of the system. However, the accumulation of expectation is real, and it has significantly raised the bar far with a properly functioning office must deliver. At the national level, the answer is more difficult. Yes, the role needs clear domestic regulation in many countries, and it is still insufficiently defined. The absence of a European template does not give national system permission to leave the office poorly secured. It means exactly the opposite. Because Strasbourg does not prescribe the form, the national legislator must do the work and give the office the authority it needs. Based on the Council of Europe Good Practice materials, particularly the 2017 guide that I mentioned and 2023 multi-country study, I would identify 6 things that any well-regulated national system must provide. First is a clear legal basis. When the agent's mandate is grounded in primary legislation, the agent can point to the legal obligation when demanding cooperation from the courts and ministries. When it rests only in a rule book, that authority is weak. We will see exactly what it means in the Serbian example. Second, access to information across government. The agent cannot litigate effectively, coordinate execution, or prepare action plans without reliable access to files, records, and explanation from every relevant domestic institution. This access must be legally granted and not dependent on the goodwill of the judges or ministers. Third, coordination authority. The actual power to convey interministerial meetings, set deadlines for responses, to push process forward when they adjourn, and with this the agent can identify what needs to happen but cannot make it happen. Fourth, sufficient resources. The Brussels Declaration of 2015 is explicit, and I will explain it later. States must provide sufficient resources to government agents responsible for coordination, because without them, even the most skilled agent becomes purely reactive, managing crises rather than building genuine compliance. Fifth, a stable connection to Strasbourg, reliable working relationship with the court registry, with the Department for the Execution of the European Court judgment, and with the permanent representation in Strasbourg. Six, a link to the political level. Some judgments require legislative changes. Some require budget decisions. Some require political commitment from the highest level of government. The agent needs a structured pathway to reach that level without necessary. If difficult cases disappear into a bureaucratic process without ever reaching anyone capable of deciding, execution is more likely be ineffective, and the Committee of Ministers can transfer the case to an enhanced procedure. I think that these 6 requirements are not invented here. They emerge from the accumulated logic of 15 years of Council of Europe guidance. And they are precisely the requirements against which we will now evaluate Serbia. And before I move to reform process, I would like to ask you a question. What do you think, which of these 6 requirements is most difficult to achieve at the national level and to provide in practice, and why? And I can hear some of the answers when we go back to Serbia. So if you can memorize what is the most difficult to achieve. The 4 roles I have described did not always look so demanding. At the beginning, the agent's roles was very easy. Over the years, the roles have expanded significantly and deliberately, and over past 15 years, it responds to a reform process that reshaped the conventional system from 2010 onwards. By the late 2000s, the European Court was facing a crisis. The Strasbourg Court became a victim of its own success. By 2010, around 140,000 applications were pending before the Strasbourg Court. New cases were arriving faster than old ones were being resolved. A person whose rights have been violated must wait 10 or 15 years for a judgment. So something had to change, and between 2010 and 2023, a series of high-level ministerial conferences produced declarations that together transformed the functional expectations placed to the state agent office, without changing Rule 35 by a single word. First event was in Interlaken in 2010, and as a result of that ministry conference, the Interlaken Declaration was adopted, and this declaration introduced the central organizing principle of the modern convention system, subsidiarity. Primary responsibility for the protection of convention rights belongs to the national level, and Strasbourg is seen and has to be seen as a safety net, not the first line of defense. For the agent, this was a fundamental shift. Interlaken process did not change the formal law of representation. What it changed was the expectation of what representation must achieve. From that moment, the agent could no longer be understood as operative only in Strasbourg. The role was pulled back into the state, into domestic courts, into ministries, legislative process, and made part of the internal machinery of compliance. The second conference was in Izmir in 2011, and Izmir Declaration institutionalized regular, structured dialogue between the court and national government agents. Meetings that are happening twice a year, where practical difficulties with court procedures are discussed together with the state agents and the registry of the court, and new working methods debated before introduction. 2012 was a high ministerial conference in Brighton, and as a result, Brighton Declaration was adopted, and Brighton made explicit what had not yet been embedded in practice. Execution of judgments does not happen automatically. States need deliberate domestic mechanisms, specific institutions, specific procedures, specific people with specific authority. Brighton called the member states, to develop these capacities and to share good practice among other countries. And for the state agent, this was a clear signal. Building the national execution mechanism is now a legal and political expectation that has to be delivered. 2015 was conference in Brussels, and the Brussels Declaration is the most direct political statement about what the state agent needs to do. It stated, I quote, "Develop and deploy sufficient resources at national level with the view to the full and effective execution of all judgments, and afford appropriate means the authority to the government agent or other official responsible for coordinating the execution of the judgment." End of quote. Brussels Declaration in 2015. This is the first time a formal declaration explicitly recognized the agent as a domestic coordinator of compliance and not only a courtroom representative. And this was a turning point for the role of the state agent within the Council of Europe framework. Authority means that the agent writes to the ministry, setting a deadline to the president of the Supreme and the Constitutional Court, and that the president and the ministry have to respond, not out of courtesy, but out of obligation that exists for the state. 2018 there was a conference in Copenhagen, and Copenhagen recognized the government agent network, very important in increasing structure of communication among agents from the different member states. For example, when the courts develops new doctrine that is affecting many countries, the agent shares their analysis through government agent network, they compare their position and coordinate responses. Reykjavik 2023 reaffirmed the convention as a central pillar of the European democracy and the rule of law. A significant statement at the time where several member states are questioning their commitments in the convention system. In that environment, the state agent becomes the domestic anchor point of convention compliance, the person inside the government whose professional identity is defined by making the convention work, even when political climate pushes in another direction. And what the reform process has done to the dual nature of the state agent. Interlaken made the agent part of the national compliance mechanism. Izmir made the agent an operative interlocutor of the court. Brighton made the agent responsible for the execution of the judgments. Brussels gave the agent the political mandate for authority and resources. Copenhagen embedded the agent in a transnational professional community, and Reykjavik positioned the agent as a guardian of conventional values in the era of political resistance. And none of these declarations amended the formal text of Rule 35, but together they transformed what compliance with the text is understood to require. At the end, the center of that transformation is the dual nature that I discussed, an agent who defends and the agent who delivers, both in the same office serving the same system. So I've been speaking in general, and now I'll continue with a more concrete Serbian experience, and I want to say something also coming from my personal experience since I've been a state agent for 4 years. What that means is that I lived a dual nature that I have been discussing. I lived this life professionally, daily, and it reshaped my personal reality. And I know what it feels like to argue the case before the court, and then after a judgment finding a violation, to sit down and ask yourself, what does it mean for the people who are affected? And what does it mean to the state? What has to change? And how do I make that happen from inside the national institutions, including not only governments, but more often highest courts, Supreme and Constitutional courts, and they did not always want to hear what I asked them. And Serbia is not a flawless model, but is a generally instructive model because it shows both what works very well and what does not, and what kind of honesty that is only possible when you have been inside of the system. Serbia, the first thing that I want to explain is 4 institutional phases that Serbian state agent went through. Serbia joined the Council of Europe in April 2003 and ratified the convention in March 2004. The question arose almost immediately, who will represent Serbia before the European Court? What followed was a 14 years process of institutional searching, and the state agent moved office 4 times. The first framework was established in 2005, and it reflected in political reality. Serbia was still a part of the state union with Montenegro, and this agent's office was a shared arrangement with alternating leadership between the 2 republics in theory, but in practice it was always a state agent from Serbia. When Montenegro declared independence in 2006, a new structure was needed for Serbia alone. Both phases kept the office within the government human rights structure and kept the court function intact. And from 2008 to 2015, the office moved into the Ministry of Justice, a more conventional, logical location with a clear line of accountability of the government. Then, very interesting thing happened in 2005. The law on the state attorney's office transferred representation before the court to that office. The agent is now simultaneously a deputy state attorney appointed by the government on the Ministry of Justice proposal for a 5-year renewable term. 4 moves in 14 years. But here is what I think it's important. Through all these different locations, the function stayed constant. Representation, execution, coordination, monitoring on convention compatibility, and the promotion of the European Court and European Convention standards. All were presented in the first decree from 2005, and they are present even today. The institution was searching for its proper location. The location changed 4 times, but the substance did not change at once, not even once. And this confirms something that I mentioned in the part 1 of my presentation. Functions are more stable than structure. The convention is not whether the office sits, it is whether it can do its job. And the 3 roles under the current Serbia system represents very significant gap. Under the law on the State Attorney's Office of 2015, the Serbian agent has 3 recognized roles and a significant problem in one of them. The first role is representation before the court. So the state agent prepares observations, respond to applicant, attend hearings, negotiate friendly settlements under Article 39 with the prior consent of the relevant organ, sign unilateral declarations. The state agent, it's very important to underline one notable constraint. The state attorney general can take over any case the agent is handling. In practice, this is rare, never happened, but the provision limits the agent's operational independence in a way that matters. The second role is coordinating execution of the European Court judgments, and here is a significant legal gap. The law clearly transferred the litigation function, but it does not give the agent an explicit statutory mandate for execution coordination. The work in the coordination of the execution of the court judgment is done, and is done very effectively, but the legal basis sits in the secondary regulation, the internal rule book of the State Attorney's Office, and in a budget law. Why this is important? Because the moment the court finds a violation, the agent needs to act as the advocate for the implementation, to push presidents of the Supreme Constitutional Court ministries to set that timelines to demand responses. That requires a clear statutory mandate. When it rests on the secondary legislation, other presidents of the court or other relevant decision makers have more room to delay or to treat the agent's request for execution of Strasbourg judgment as advisory, not as a binding request. The example that I will give is simple. Imagine a judgment requiring the Ministry of Interior to reform its detention procedure. When a clear statutory base exists, the Ministry has a legal obligation to respond, and with only a rule book, internal rule book provision, it can treat the agent's letter as a suggestion. That is the real-world consequence of the normative fragmentation, and is directly weakening the second dimension of the agent's role. The third role that Serbian state agent has within the Serbian legal system is the convention guardian function. Article 16 of the national law provides that if the office finds a domestic provision incompatible with the convention, it must inform the relevant authorities of the need to harmonize the provision. The rule book, the same internal rule book, adds that the agent has to promote European Convention awareness, to public reports, to participate in the Council of Europe expert bodies, to inform domestic courts about relevant European Convention court developments, and very important, this is a very important rule, and again, it sits on the secondary regulation, not in a primary law. Now I want to speak for a moment what the dual nature actually looks like when you're living it. When you're preparing observation in the case that the government strongly contested, a case involving serious allegation, politically sensitive facts, you are advocating for the state. You gather the facts as carefully as you can. You make the legal arguments as strongly as the evidence allows you. You believe in what you are doing because the state generally needs someone to present its position coherently and professionally. And then the judgment with the violation arrives. the court finds a violation and something in the dynamic of that position changes entirely. You read the judgment and you understand, sometimes immediately and sometimes gradually, what it means. Not just for the applicant, but for the entire system, for the other people in similar situations, for the structural problem that produces the crisis in the first place. At that point, the question becomes, what does justice actually require? Not what is the minimum that states can do to close the case before the Committee of Ministers, but what does generally compliance looks like, and what actually applicants need, and what needs to change so that this violation will not happen to some other person. And to answer to these questions requires you to push internally against resistance that is sometimes generally institutional inertia and sometimes deliberate avoidance. To call meetings that people maybe do not want to attend. To call meetings, to write letters that presidents of the court or ministers would prefer to overlook. To stand before the Committee of Ministers in the debate in Strasbourg and to say, here is what we have done, knowing that what you have done is real and not just on paper. And this is the dual nature as lived experience. It is demanding in a way that purely adversarial legal works is not, because adversarial work at least has clear sides. The execution dimension requires you to be simultaneously a loyal government official and a genuine advocate for the system working as it should and the advocate of the applicant. And this is a very difficult balance. For me, at least, it was one of the most important balances that I had to do in my professional life. I want to close the Serbian section with the most concrete and most pressing structural problem, resources. Over the past 10 years, Serbia has consistently ranked among top 10 member states of the Council of Europe by number of pending cases before the European Court. For a country of almost 7 million people, that is a remarkable and sobering figure. One that placed an extraordinary demand on the agent office, whose resources have never been scaled to match the expectation. Against that constant caseload, the state agents has operated with 6, 7 lawyers sometimes, responsible simultaneously for litigation and execution coordination across hundreds of active cases at any given moment. I will compare it to Croatia. With roughly 1/3 of Serbia's case law, Croatia at one point maintained 18 lawyers in the agent's office. Each Croatian lawyer at that time handled at approximately 30 cases, and at the same time, each Serbian lawyer handled approximately 250 cases. This ratio is not sustainable. It creates a systemic risk. To litigate quality, to execution time on the time, and to the convention guardian function, which is always the first thing that is sacrificed, day-to-day pressure becomes overwhelming. The remarkable fact is that despite this disproportion, the Serbian agent office has functioned effectively and has been cited several times by the Committee of Ministers as an example of good practice in the execution coordination. This is a testament to the dedication of the people who were working there. But it cannot be used as an argument that the current situation is acceptable. It is not. The gap between caseload and the capacity is structured exposure, and it requires legislative and budgetary attention. I will close this section by evaluating Serbia against the 6 requirements from the part 2 that I mentioned. First, legal basis. It is partial. Litigation is there is a clearly statutory foundation. Execution, coordination, and convention guardian role exist only in the internal rule book. The gap between what the office does and what the primary statute explicitly authorizes is a real weakness that affects authority in practice. Access to information, very strong. Article 8 of the law on the State Attorney's Office imposes a clear statutory obligation on all state bodies and courts to provide files, documents, and explanations. This is a very solid foundation. Third requirement, coordination authority. It's partially regulated. It is recognized in the internal rule book and not in the primary legislation. It works in practice, but the legal foundation is weaker than it should be. Fourth, resources. I think they are insufficient. 6 or 7 lawyers in the last few years for more than 80 cases now pending cases. I think this represents the most urgent problem that Serbia has. Strasbourg connection, strong. The agent attends Committee of Ministers meetings, submits action plans and action reports, maintain active communication with the Department for the execution of the court judgment. This external dimension functions very well. Political level link, partial. The agent reports through the State Attorney General, who reports annually to the government and the parliament. Under the earlier decree system, the agent reported directly to the government every 6 months. The current pathway is less direct and less frequent, and for politically complex execution cases, that can create a distance that is important in some cases. And overall, I think that Serbia demonstrates both the presence of the functional court and the real challenges of fully stabilizing. It is an honest illustration for me of what the dual nature demands institutionally, and where gaps between legal framework and institutional practice creates vulnerabilities that eventually affect real people. And to conclude, I will bring everything together with 3 conclusions and a final image. First, role of the state agent is formally minimally regulated and functionally is central within the convention system. As I mentioned, Rule 35 gives us 19 words. The role that has grown up around those 19 words is one of the most functionally important in the entire convention system. The agent is the main interface between the national legal order and Strasbourg. It presents at the start of every case, and it closes every execution process. The formal minimalism, as I explained, is not a legal gap. It is a structural choice that allows the system domestically to work across 46 different constitutional orders. It places the burden of institutional construction on member states. Where that construction is incomplete, like Serbia illustrates, the dual nature of the office is harder to sustain. Second, the dual nature is a defining feature. The state agent defends the state, and then the state agents deliver justice to the individual. Both functions in the same office, in the same role, in the same person. And it's not a contradiction, it is the most sophisticated feature of the convention system design. The person who knows the case law deeply from the litigation phase carries the knowledge directly into the execution phase. However, this dual nature is only an asset with the function when the office is strong enough, resources are good, and independent is enough to perform both functions with genuine integrity. When those conditions are not there, the dual nature becomes a liability. Third, there is no single correct design for the state agent's office, and there is likely to be one. There is no likely to be one. National variation is a feature of the system, every system, not a defect. But there is one test any national system must ask. Can the office perform its function effectively? Can it litigate with authority, coordinate execution with institutional leverage, guard convention standards domestically, and sustain both dimensions of its dual role simultaneously? And the 6 requires that I mentioned: legal basis, information access, coordination authority, resources, Strasbourg connection, and political level link are the operational expression of that test. Any state that takes its convention obligations seriously should ask honestly whether the agent office passes all these requirements. And I will close with the image that captures the agent's position more honestly than any formal definition. When a Strasbourg judgment is issued, who actually makes it real? Who translates it from a document in the court archives into a changed law, a reform practice, a compensate individual, a prison cell that is no longer inhuman? Formally, the state, a whole network of institutions. In practice, very often, the process begins in the agent's office. That is where the judgment is first read and understood. That is where it becomes a list of tasks assigned to specific national authorities. That is where the action plan is drafted, the timeline is tracked, and the dialogue with Strasbourg is maintained. The agent does not replace other domestic institutions, but agent is very often what makes their interaction possible. And the agent, and its dual role that he has, is both the person who argues that no violation happened and the person responsible for ensuring the violation is remedied. Jean-Paul Costa, one of the most famous presidents of the European Court of Human Rights, described at one event government agent and servants of law and rights, not servants of government, servants of law and rights. And I believe this phrase captures everything. The agent defends the state, and in doing so serves the state's obligation to the law. Those two things are not in conflict, they are, or they should be, the same thing. If the convention system succeeds, if it produces judgment and actual change, it is because within each state there exists an office capable of transforming those judgments into reality. And in most systems, this office is a state agent. Thank you.